Welcome, everyone. My name is Katerina Linos, and I'm Associate Director of the Institute of European Studies here at UC Berkeley. We're honored to have you with us today for a panel discussion titled Constitution Making by Judicial Fiat, Past and Present Perspectives. This discussion features the expertise of Professor Amedeo Arena and Professor Martin Nettesheim. We will also have moderation by our own Professor Katerina Linos. Katerina.
Thank you so much, Akasemi. It's really delightful to be here at a moment when the U.S. Supreme Court and U.S. Congress don't seem to be venues for rapid or progressive or substantive change. It's amazing to see what the European Union does, and in particular, what the Commission, what the courts, how functional those institutions are in the face of new challenges. So I'm delighted that we are able to be here today. My name is Katerina Linos. I'm professor at the law school where I direct the Miller Center for Global Challenges of the Law, which is co-sponsoring with Akasemi and IS this event. I will first introduce our speaker, Amedeo Arena, who's coming to us from the University of Naples, where he is a full professor of the Faculty of Law, as well as a senior fellow at the Institute for European Studies. He is best known for his work on the making of the Europe's Supremacy Clause. He'll be talking about European history, a particular decision, Costa vis ENEL, that establishes supremacy. Then with us, we will have Professor Martin Nettesheim, who spends a lot of his time here at Berkeley, and is also a professor at Tuebingen. He will be speaking about the European Court of Justice and Europe's self-description, in addition to his important theoretical work on the court and banking. He frequently practices and intimately knows the institutions and exactly how arguments can be won or lost before this important institution. Our discussant is Professor Dick Buxbaum, who has many national and international titles, but today I will just mention one, that the 1964 foundational decision that Professor Arena will be discussing, Costa vis ENEL, was one in which Professor Buxbaum actively participated and has firsthand knowledge of. So as moderator, I will be strict about time. Each speaker gets 10 minutes maximum. A little bell will ring at 15 minutes, and also at 11 o'clock sharp, so that we make sure to be as focused as possible.
All right. Good morning, everyone. Well, I'm really honored to be here. Thanks for having me. And so today I'll be speaking about the past, because as you probably will see, past is prologue when it comes to issues of supremacy in the European Union. And in particular about the making of what is regarded as Europe's Marbury versus Madison, that is to say the Costa vis ENEL case. And I think here we can strike a comparison and introduce this concept that was coined by Danny Halberstram from Michigan Law School of European piecemeal constitution. So essentially, in the United States, supremacy was clearly stated in the Supremacy Clause in the 1787 Constitution. Constitution and federal is the supreme law of the land. Judges in the states shall be bound thereby. Nothing in the Constitution or all laws of the states notwithstanding. So the Constitution already provided what in EU law we would call both supremacy and the direct effect of federal law. What about judicial review? Well, some would say it's a corollary of these two principles. Anyway, it came about a few years later, in 1797, with Weir versus Hilton. That was the supremacy of treaties concluded by the United States, namely the Treaty of Paris, the one negotiated by Benjamin Franklin, by the way, is a treaty with Great Britain over state law. And but of course, you know, the leading case is considered Marbury versus Madison of 1803. Was it obvious? Well, Jeffersonian maybe didn't think that the Supreme Court had a judicial review powers was an obvious corollary, but that's how the story went. So let's see what happened in Europe, because needless to say, the Treaty of Rome 1957 did not include the so this story starts a little bit earlier, in October 1962, when some American spy planes flying over Cuba found that there were nuclear missiles being prepped for launch, and they could strike major American cities on the East Coast. So how was this possible? Why the crucial take such a bold move of placing nukes in America's backyard? Well, it turns out that it was just trying to match the nuclear deterrence of the United States, which had placed nuclear missile bases in Europe, namely in Turkey, in the UK, and in Italy. There were a number of, Jupiter missile, and Leningrad and Moscow were within range. So that was possible thanks to a pro-American foreign policy of the Christian Democrat that was the leading Italian party at the moment. You can see here Pampani and Kennedy in the Oval Office. They seem to be on pretty good terms from the photo, we would argue. However, things were not going too well for the Christian democracy at the turn of the decade because it was losing support, electoral support. Instead, the left-wing parties, the Socialist Party and the Communist Party, were gaining ground. So how could the Democrats remain in power and continue their pro-American policy, foreign policy, and keep the nuclear missile bases, which of course at the time was very important? Well, the solution was an unprecedented alliance with the Italian Socialist Party. The Christian Democracy decided to strike this alliance with the Italian Socialist Party. At the beginning, that party lent its external support to the Christian Democrats, and then it became part of a proper alliance took place. However, nothing is free in life, and there was a quid pro quo. And the quid pro quo the socialists asked for was the nationalization of electricity production and distribution in Italy. Now, when we talk about nationalization, we usually think about failing firms. That wasn't the case at all. Italy was booming. Those were the days of Italian economic miracle, and electricity production and distribution was a profitable oligopoly in the hands of local monopolists called the electric barons. And many middle classes, many people from middle class would have shares in municipal companies, such as the Milanese company, Edison Volta. And nationalization wasn't really a very good deal for them because they would lose these shares as the assets of these companies would be transferred to a newly established state company called ENEL, and they could change that for these bonds. So that, of course, they didn't have voting rights, and also economically, that was a very bad deal for small investors. So there was a strong opposition to the nationalization. There were rallies, there were demonstrations. Most importantly, the center-right parties, the liberals and the monarchists, they believed that this was the first step towards Italy transition to a sort of a socialist economy. And so they wanted to oppose it at all costs. One of the most vocal opponents of nationalization was Gian Galeazzo Spandardi. So he was a scholar and a professor in Milan, who wrote a book on the relationship between community law and Italian law. And of course, he was also a candidate for the monarchy party, so he wasn't absolutely happy about what was going on. So of course, he used his skills and knowledge against that particular statute. And this is where Flaminio Costa comes in. Flaminio Costa was another Milanese lawyer, also monarchist leading, and he was a user and shareholder of one of the nationalized companies. He refused to pay the first electricity bill he received, not from Edison Volta, but from the newly established ENEL company. And the Milanese judge, Judicial conciliatory hearing the case, decided to refer it to the Italian Constitutional Court in Rome because Costa and Spandardi claimed that the law was unconstitutional. However, the Constitutional Court dismissed these claims and claimed that the community law in the Italian legal order had the rank of its ratification statute. Therefore, the ENEL statute, the nationalization statute, would prevail because it was the later statute. Was it a defeat foretold? Was it predictable? Probably so. The court espoused, in line with Italy's dualist tradition, the most common conception of the relationship between treaties and domestic law. And also from a political perspective, it was simply unthinkable that the Italian Constitutional Court would strike down what was the linchpin of the alliance between the socialists and the Christian Democrats at the height of war. However, Standardi and the discourse dismayed the community circles, of course, because they argued that this could severely jeopardize European integration. However, Standardi and Costa had an ace up their sleeve, so as soon as they learned that the first national court was not willing to refer the matter to the Court of Justice, as they asked, they initiated another set of proceedings in front of another judge, and the judge this time was Vittorio Emanuele Fabbri, also a lawyer and also a monarchist sympathizer, who this time made two references, one to the Constitutional Court and another to the Court of Justice, and that was the very first Italian reference to the Court of Justice. In front of the Court of Justice, Standardi went all in. He claimed that the nationalization was a measure worthy of the Middle Ages, when tyrants sought to tear Europe up in pieces, where the purpose of the EEC was to unify Europe. Also, he claimed that the nationalization preluded to a transition of the Italian economy to the application of the doctrines of Marx, Engels, and Lenin, and also hinted at something that is legally very important, the possibility that every national court, should the Court of Justice find an inconsistency between community law and national law, could set aside national law. We will briefly see the positions of the other party. So Monaco was representing the Italian government, and he claimed that the reference was inadmissible because the Italian Constitutional Court had already declared that the later status would prevail. Instead, the European Commission, Marchesini, they follow up this dramatization kind of strategy, showing what the nefarious consequence for the internal market would be if the national law were to prevail in member states' legal orders. Massimo Severo Giannini represented ENEL instead to try to minimize the consequences of this ruling. And then we have the Advocate General, who claimed that indeed the primacy of community law in domestic legal orders was a constitutional problem that had to be solved by each member state, hopefully in a satisfactory way as in the Netherlands. But the court gave this absolutely groundbreaking ruling, according to which the trigger rule carried with it a permanent limitation of the sovereign rights of member states against the subsequent unilateral act cannot prevail. Therefore, the treaty, in particular Article 177, had to be applied regardless of any domestic law, which I think is very similar to the Supremacy clause in the American Constitution, any state law notwithstanding. What I think is an interesting parallel with Marbury versus Madison is just as Marbury versus Madison was a political compromise for introducing judicial review, but then ruling in favor of the Jeffersonians. That's something of what happened in Costa Enel, because the court affirmed the primacy of community law, but did not really strike down the nationalization statute. It interpreted very narrowly the provisions of the EEC treaty that, according to Standardi and Costa, were in conflict with this provision. And also, this judgment wasn't reported by the Italian newspapers because the print workers were on strike, so it escaped the attention of the general public, of course, not of academic commentators. So, epilogue of the case came back to Judge Fabbri, who, of course, was very happy to receive the judgment and ruled that the ENEL statute, according to his view, because the Court of Justice left the National Court to determine whether there was a conflict with one or more of those provisions, he thought that there was a conflict and decided to set aside the law. And the epilogue of the saga was before the Corte di Cassazione, our Supreme Court, which found that, as a matter of fact, Costa had no legal interest in bringing proceedings, which again reminds me of what has been said about Madison having a conflict, Marshall having a conflict of interest in Marbury versus Madison, considering that he was the one who should have served this, who should have delivered this commission. So there are, of course, a number of narratives concerning this judgment. One is that it was a tale of judicial empowerment. So the Court of Justice and National Court saw this supremacy, principle of supremacy, as an opportunity to exercise judicial review together. And so this is kind of a paragraph from the courts. Interestingly, the Court of Justice did not do it by itself, but left the task to set aside statutes to national courts. According instead to another narrative, which I think is even more interesting, that is that it was a story of a legal mobilization. Indeed, this case was clearly conceived by a mastermind, a profound connoisseur of the relationship between Italian and community law, such as Gian Galeazzo Bernardi. So there would be like a ghostwriter, similar, suggesting the solution, as in his picture from Honoré Daumier. But they just don't take my word for it. But I'm sorry, the other narrative is that it was an idea of nuclear fusion. That is to say that fusion of sovereignty, of course, is something of the nuclei of sovereignty is something that only can take under conditions of extreme pressure. In this case, there was, of course, pressure, geopolitical pressure from the Soviet Union, plus legal pressure from the Italian Constitutional Court. So probably the formation of supremacy was a kind of response to this particular situation. And thank you very much. I look forward to the next one.
Thank you. Well, thank you very much for having me here. Thank you to the Center and also to the Law School for the opportunity to now look at the present developments. It's the purpose of this presentation today to discuss the most radical and fundamental restructuring of the EU, at least since the Maastricht Treaty came into force. The architecture of the EU and its member states is currently undergoing a deep and far-reaching transformation. Looking back on this phase later, one might actually be tempted to recognize a constitutional moment. This transformation is taking place without the treaty-making member states of the EU taking action under Article 48 of the treaty. It is being carried out by EU institutions on the basis of existing treaty law. And for the time being, this is crisis-driven reaction to developments that the treaty-making states did not foresee. In light of the developments in both Hungary and Poland, EU institutions are trying to combat political regressions and the rise of illiberal and ethno-nationalist policies. Who wants to oppose this? Many superficial observers therefore cheer the institutions of the EU unreservedly. Far too little is seen in the political public sphere of how far-reaching the reinterpretation of the EU treaties and the reinterpretation of the relationship between the EU and its member states is, on the basis of which the struggle is being waged. Could the old political wisdom prove true that fighting one problem often creates a second problem? I would like to make clear in this room and in this presentation that it is a major problem for every European citizen and a genuine political challenge when member states abandon the political liberal consensus. But the good end does not justify any means. The constitutional transformation will not be reversed even if these member states were returning to liberal political principles. Benevolent observers see a development that strengthens and deepens European integration. They consider it to be both a creative and legally permissible reinterpretation of the treaties in the sort of furthering of European and deepening of European integration. One of the justices recently told me in private, never waste a good crisis. Others believe they can identify a clear transgression of what is being permissible or what is permissible. The court is as deeply divided, the members of the court are as deeply divided as never before. It is just not visible in public because of the impossibility to publish dissenting opinions. In private conversations, however, the deep uneasiness emerges that some of the members of the court feel vis-à-vis the development of the case law on the basis of Article 2 of the treaty. And when you look at the composition of the court, it is at least astonishing to see how some of the most senior members of the court, known for their skepticism about the court-driven federalization of the EU, were recently stripped of the presidency of the court, of one of the court's chambers. The court's power grab is leaving its mark on the institutional organization of the court. Let me go into detail, and I don't have a lot of time, so I should skip through some parts of my manuscript. The EU was established as a club of sovereign states, which delegated the realization of individual political projects to the EU institutions. The EU institutions were limited to implementing, as the German Constitutional Court frames it, an integration program in clearly defined fields, and they're responsible to the EU member states in a principal-agent relationship. The basic constitutional relationship has not been changed in the last 50, 70 years, and it would have actually also not been changed to the constitutional treaty drafted in 2004. However, this basic constitutional relationship is now currently being incrementally rewritten by the EU Commission and the European Court of Justice for a good 10 years. As a consequence of this reinterpretation of the treaties, a federalist restructuring of the EU is becoming visible. Important EU actors are now driven by the vision of transforming a quasi-international organization controlled by the member states into a federal structure in which the EU level does not only claim legal and legitimatory of autonomy. It would be a different talk to talk about the idea of autonomy of EU law that the Court of Justice has developed, but also exercises supervisory powers of the EU member states through quasi-federal or federalist constitutional requirements. The programmatic and also axiological value statements contained in Article 2 of the treaty are being rewritten as virtually enforceable legal obligations. The process is manifest in several areas of EU treaty law. First, the member states' scope of action is almost all political areas is now framed through EU law by the extension of the scope of application of the EU fundamental rights beyond the formulation of Article 51 of the Charter of the Fundamental Rights of the European Union. Starting in 2013, the Court has taken the position that the Charter applies in all areas in which EU law exists or applies. Obviously, this has both harmonizing and federalizing effect. Second, important member state policies are now subjected to EU or community law oversight through the interpretation of the provisions of EU citizenship. Just yesterday, the European Commission initiated treaty infringement proceedings against Malta, claiming that the golden visa scheme violates EU law. Again, from the political point of view, if I were talking here as a citizen of Europe, Malta is certainly abusing its position within the EU area of free movement by selling the right to settle down in other member states. But if the EU Commission will get its way in the legal proceeding, the member states will have lost the sovereign power to grant or withdraw their citizenship, clearly against the wording of the treaty. And third, most importantly, involving everything, the European Court of Justice is now subjecting the institutional self-organization of the member states to EU law requirements on the basis of Article 2 of the treaty. Up to now, the court has been primarily concerned with subjecting the judicial organization of the member states to supervision under EU law. 2 and 19 of the treaty are the relevant provisions. At present, the main issue is the formulation and enforcement of the rule of law requirements with which the EU member states must comply, probably also because the EU would find itself in a delicate situation if it were also formulating democratic expectations. But there's certainly no reason not to rewrite further values of Article 2 of the treaty as obligations with union or community enforcement and judicial overview by the Court of Justice. It seems to me at least quite possible and thus also foreseeable, for example, that the Court of Justice will design a parallel federalist supervisory frame for member states' legislation and administration. If you can subject the judiciary to these kind of mechanisms, why not the legislator or the administration? If it is true that the member state courts are also, what is now usually said, community courts, this also certainly applies to member state legislators and administrative bodies. Additionally, the rule of law is defined so broadly that it also includes elections, the media, and other issues. It is evident that constitutional oversight of the EU institutions, it has become a general structural principle of the EU, even if it is currently in the process of being sort of formulated and spelled out. In sum, as a consequence of this free interpretation of EU law, EU law is now framing and limiting member states' scope for action, both regard to questions of substantive issues, but more importantly also to questions of constitutional and institutional self-organization, that's sort of the heart of state sovereignty. I'm not talking here about whether this is good or bad development, a good or bad development from a political standpoint. I'm only concerned with the question of whether such a development of the treaty and its interpretation should be entrusted to the EU institutions without a treaty-making process. It is also, of course, about the normative question of whether the EU institutions have the political and also constitutional legitimacy and the necessary political capital to drive such a restructuring of the EU. Unfortunately, the time is lacking. Professor Linos is looking at me. I could actually go on, but I want to perhaps
during the 4 minutes of the extension.
yeah, but I could go on and sort of sketch how certain member states and courts have reacted to that. It is perhaps for me at least coming from Germany most interesting to see that the German Constitutional Court is waging this senseless battle against the reorganization of the European Central Bank and the reformulation of central bank policies, while at the same time accepting what is happening in this much more fundamental and much more important area of constitutional supervision. On the other hand, the Polish court, as you might have certainly heard, came down with a judgment last year, which was against a clear overreach of how to react to these problems, and thus was also delegitimizing itself and also the way to deal with these problems. I want to stop here. I think you got a sense. I was not able to look at the individual cases and describe it. This was not a sort of case law analysis here today. It was a political essay. At least I want to sort of make you sensitive for what's going on, and I want to invite you to take a position on how you look at that. Thank you very much.
Well, each of these presentations was a tour de force and deserves its own 15 minutes of analysis, variation, rebuttal, etc. But that's not feasible. So I'm going to limit myself to talking about the fact that hard cases make bad law, and also hard framing of basic treaty instruments make bad law. The unanimity problems that prevent treaty-based solutions create a dilemma. Right? The issues both of the type that President Nettesheim discussed, and the questions of the Marburg-Madison arrogation of authority by the European Justice make for difficulties. It's a dilemma that I don't think can be resolved because the original structure, or not the original, but the current structure of the treaty arrangement for these parties makes a putt, makes a dilemma in any way you look at it. So, first, a couple of minor comments. I did watch the Costa and hearing. I wasn't participating, I was listening. And it was the first time that the Chief Justice, still Donner, stopped, and actually it was an Italian advocate who was getting rather too florid and too lengthy, and actually stopped and said, "You don't have that much time," which was a scandal. I mean, some of the court members said, "What have you just said?" You know, it was the very first time that the idea came up that an advocate might be shackled, you know, in that sense. I leave that aside. I also leave aside that our late colleague, Professor Wiesenfeld, would have argued with you, on the question, which was the starting point. He would say Van Gent and Los was the starting point, and that Costa was simply a continuation, a significant strengthening, but by no means the novum here. So I would just throw that in, that Costa, although it was a much less politically frame, I mean, the context of Costa was not purely political in that sense. It was none, I mean, of Van Gent. It was nonetheless the first point. Now, I want to pick up simply one or two areas here. One is that when you get to this current issue of the removal of resources from Poland and Hungary, right, because of their illiberal democracy, it reminds me of the constitutional problems in the United States in the 1930s, where the taxing power of the federal government had quite significant limits, but the spending power, right, could create conditions under which the money would flow to the states that were almost without limit. They were not totally without limit, but the breadth of the margin of discretion for the congressional use of the spending power to guide policies, right, was very large. And of course, in a sense, what's in Europe today, I mean, this is a spending power issue, you know, from that standpoint. Now, a second issue that I would really want to put into this is that Article 2 has not only been used for purposes of insinuating concepts of democratic obligations into the states. It's actually, and you should blame your German colleague von Dumbitz for much of this. It is actually also being used to reestablish the European Union institutions as a power vis-a-vis other international institutions, starting with CADI and the Security Council. I mean, you can't get much more courageous or foolhardy than that, right? That you find in the treaty a mechanism to say to the states, yes, you may be obligated under the council membership to X, but you are obligated under your membership here to non-X. And that is, of course, not only CADI, that has gone on and on. We're now in the privacy issues. You know, we're in a whole lot of issues. And it is, I have to say, it's the German member of the court that has been, in a sense, the spearhead of this. You may have some, I don't know, maybe some moderation of that comment, but it strikes me that that's where it comes from. So your fight needs to be with your fellow, with your Heidelberg professor next door in that context. So those are my main issues. I do want to say something about judicial arrogation of authority. In my mind, a lot of the courts generating quasi-constitutional issues, like through the freedom of establishment clause and so forth, came both in Europe. The institutions of the community were not. This is the community institutions were not responding. Right? My field is more corporation law, and it was very clear there, so that the court was going to create a quasi-constitutional doctrine through the centrist cases and its follow-up for also for these reasons, that when the one institution freezes, another has to, in a sense, jump in. That's an American law. You know, we wouldn't have had Brown against the Board of Education if it weren't for the fact that Senator Fulbright was politically unable, as much as he wished to do it, to move the Southern groups towards some desegregation of their school system. When one institution within that framework gets locked up, right, sometimes another has to come in, and that creates all the issues that Professor Nettesheim is speaking about. It's inevitable. hard cases make bad law, and hard structures make for breaks in that structure that maybe cause some damage, collateral, or maybe even central damage to what's going on. I'll stop there. Those, I think, were mainly some reactions to both wonderful